So, welcome everybody. I'm very happy to have all of you here today for our April webinar. My name is Benedict Schöpflin. I'm the Executive Director of the Canadian Network for the Prevention of Elder Abuse. And I'm very excited to have you present today for this very exciting webinar. We're going to be looking at the improved and brand new practical guide to elder abuse and neglect law in Canada with Krista James, the National Director of the Canadian Centre for Elder Law. You can see on your screen right here. Before we get into the meat of it all, I want to go through a few housekeeping reminders for everyone. So first things first, this webinar is being recorded, as you know, so all of you are muted right now, and we'll be posting the recording later on today. If you're attending through your computer, make sure that your sound is turned on or up all the way and that your headphones are plugged in all the way. If you're experiencing any form of connection or sound issues, briefly, the best way is always the simplest way. Close the window, hang up, start again. And also letting you know today that the closed captioning is available. So you should be able to access it. I believe on your end, it's under your settings, which might look like a little cog icon. Please correct me if I am wrong, but last time I checked, that's what it looked like. Couple of things about today's presentation. We will have 15 minutes at the end for a Q&A, and Krista has already announced that if we have a lot of questions, she is able to stay on a bit longer to take a few extra questions. You'll notice that you have a chat box and a Q&A box. The chat box is for introducing yourselves, sharing comments, sharing resources. Today we have Sarah Pon, who is also from the Canadian Centre for Elder Law. She is monitoring the chat box and she'll be popping in here and there, adding a few links and resources that might be useful while Krista is speaking. And if you have questions for Krista, put them in the Q&A box. Those are the ones that I will be reading at the end. Feel free to type them up at any given point during the presentation. We'll go through all of them at the end. And a reminder, Krista will not be providing legal advice. And for that reason, we're also asking you to be very mindful of your privacy and other people's privacy. You know, this being recorded and made public, please don't share any details of individual cases. It's very important to us to make sure that everybody is safe and that their information is not just shared randomly. And of course, if you need to go before the end, don't worry, we will be posting both the slides and the recording of this presentation on cnpea.ca a little bit later today. I would like to begin this session officially by acknowledging that the land on which I live and work is the unceded territory of the Coast Salish people, which includes the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. And without further ado, I'm very happy to introduce Krista James. Some of you might know her already. She's done some wonderful presentations with us, and she's a regular partner of CNPEA. Krista is the National Director of the Canadian Centre for Elder Law. Her work addresses legal and policy issues that are linked to aging, and her interest is particularly in looking at how aging, gender, and other aspects of identity intersect. Here is her contact information at the bottom of this slide, and we'll make sure to share that with you after the webinar as well, if you have questions and follow-up comments. This said, Krista, I think it's your turn to take over. I'll stop sharing my screen and go ahead.
Hi, everyone. I'm just going to share my screen so you can see my slides. Do you see the slides okay, Benedict?
Yes, I do.
Great. Okay, well, hi, everyone. Thank you so much for showing up to hear this presentation. I have had a bit of crackly bit with Benedict's voice, so we'll just hope for the best with the wireless signal. And as Benedict said, everything will be sent to folks, the recording. You can access the recording and the PDF of the presentation after. And I'll just speak slowly and hopefully we won't miss anything today. What I want to do today is talk about our new practical guide to elder abuse and neglect law in Canada, which has just been launched as a bilingual French and English website just this morning. So what I'm going to do in this talk is outline some key features of the website, and I will do that by demonstrating the website. So I'm going to kind of toggle back and forth between the web platform and also this slideshow. And then after giving you a brief overview of the website and how it works, I want to do a little bit of a legal teaching session. So I'm going to talk about some of the key laws that are relevant to elder abuse and neglect response across the country, all of which are found on the Practical Guide website. And then I'm going to close with identifying some best practices for response, which are kind of grounded in the law but not reducible to law, and some closing words on how some things I think it's important to consider when you're trying to figure out what's the best response to elder abuse and neglect in a given situation. This will be a fairly high overview of the legislation because I want to make sure it's relevant to everyone, so it's not a deep dive into any particular province and territory. You can use the guide in your own time to learn more about the laws in the province and territory in which you work. The guide also does have some information on federal laws that apply across Canada as well. So just a few quick sort of disclaimers. First of all, elder abuse law, the laws I'm talking about today are mostly colonial constructs. Some of the individual bands have developed their own policy related to elder abuse and neglect response, and I'm going to talk about that briefly in this talk. As Benedict mentioned, I cannot give any legal advice today, but I will try to help you problem solve where to find the right laws in your province and territory. I can't believe I'm getting an emergency text from my kiddo right now in the middle of this talk, but that's how life goes. Ignoring it, it's fine. Not an emergency. Emergency in her mind, but not a real emergency. And if you ask questions, please be mindful of people's confidentiality because, general things you say about people's personal stories can actually reveal more personal information than you think. If you're unsure, feel free to email me after this talk, and I can connect you with someone who can answer your question or maybe point you to the right laws. Just briefly about the Canadian Centre for Elder Law, we do research and develop reports and educational tools about legal and policy issues related to aging. We're actually part of a larger organization called the British Columbia Law Institute, which is BC's nonprofit law reform agency. We have a website separate but connected to the Practical Guide website. So that appears on this URL, and there'll be a link to all the material I've mentioned in my slide. There'll be hyperlinks. So there's a hyperlink here to our website. And our work tries to help governments to improve laws. As part of that work, we do a lot of consultation with seniors and people who work with seniors across the country. But we do try to make everything we create available for free from our website. This slide just highlights a few of the other projects that we're working on at the CCEL. Our work includes more than elder abuse and neglect response. In particular, we're working to develop a number of resources related to supporting the decision-making capacity of people living with dementia. Again, there's hyperlinks in this slide deck here, so I'm not going to go into these specific projects in detail because I know you're kind of more here to learn about elder abuse and neglect law today. Really, I can skip over the slide about myself. You've already seen my face twice, and that's more than enough, but this slide does have a hyperlink. I just wanted to flag both to our website and to my Twitter identity, where I do try to share lots of useful information on abuse and neglect response in Canada. My office is located on Musqueam land, unceded Musqueam territory in the province of British Columbia. But I'm normally working from home, which is on unceded Coast Salish territory, Squamish, Musqueam, and Tsleil-Waututh people. I really sort of kind of cut my teeth as a lawyer working with Indigenous women in the downtown east side. So hopefully this resource that we're presenting to you today sort of considers some of the unique experiences of Indigenous people who are experiencing abuse and neglect as well. So the new Practical Guide, what are we covering in this resource? Here's a screenshot of the landing page, and this gives you a link to the website, ccelderlaw.ca. It's actually the same as the Twitter handle for the Canadian Centre for Elder Law. That's the picture you're looking for when you go to the landing page. So the Practical Guide to Elder Abuse and Neglect Law in Canada has a number of different components. Certainly it includes the law, but it's not completely reducible to the law. It's a French-English bilingual website, and what that means is there's a little button at the top where you can toggle between French and English, choose the language that works for you. There's modules on the law in each province and territory, and there's a star in the slide here because I'm going to focus on provincial and territorial laws. Laws in 3 areas. I'm going to focus on adult protection legislation, family violence legislation, and legislation that applies to abuse and neglect in long-term care. We do have information on the website on key federal legislation that applies to abuse and neglect response, in addition to provincial and territorial laws. But most of the legislation that applies to abuse and neglect response falls in the jurisdiction of the provinces and territories. The website includes 5 lenses for inclusive practice and 12 guiding principles for best practice. There's a small section on criminal law, a glossary of terms, and there's links to other resources and some basic information on abuse and neglect. This slide shows you the different areas of law that we cover in each of the provincial and territorial snapshots. So the first 3 are the areas of law that I'm going to talk about today: adult protection laws, laws applying to long-term care, and family violence laws. But you can see we cover other stuff such as employment leave for family violence, privacy law. We have a large section for each province and territory module on financial substitute decision makers and the ways to respond if you're concerned about something they're doing that might be problematic, because we tend to get a lot of questions about financial abuse at the CCEL. We have a section on how to respond to abuse if it's if you think it's a regulated professional who's being abusive in either a long-term care setting or a community setting, acute setting. Some information on policy such as criminal prosecution policy in the context of elder abuse or neglect, and access to income assistance for sponsored immigrants when they've experienced a breakdown in that sponsorship relationship. And we also have a quite lengthy section for each jurisdictional profile on key agencies for information assistance. Now, if you think there's an important agency that's not included in that, send us that information. One of the joys of a website is it makes it much easier for us to add important information as it comes up and grow the website to suit people's needs. Those of you in Ontario are probably thinking about how long-term care legislation, they've just announced it's going to be changing next week. Well, we will try to update the website as soon as possible to reflect changes in the laws as they occur. Currently, the website is accurate to today. As I mentioned, we have 5 lenses for inclusive practice that we've included to support best practices. They are trauma-informed practice, cultural safety and humility, age, dementia, and disability-friendly practice, how to consider gender dynamics in your elder abuse response, and sexual orientation and gender identity inclusion. You know, the right way to respond to abuse and neglect often depends on that unique older adult. And so these lenses should help you to kind of think in an inclusive and holistic way about responding to abuse and neglect. We have 3 funders who supported us to deliver this guide to you. They are the Government of Canada, the BC Association of Community Response Networks, and more recently, Elder Abuse Prevention Ontario. We're so grateful for this help to create this guide. It's no small feat and no small cost to make an interactive resource available in 2 languages. So now, before I switch to talking about the provincial and territorial laws, I'd like to give you a look at the website. So let's see. Right. Now, hopefully you can all see the website right now. This is the landing page. You can see at the top, in the corner on the right, you can choose Français, French, if you want to switch to French or go back to English. I'm going to play with the guide right now in English. And Benedict and I have plans to do a French webinar in the near future. So most importantly, at the top here, there's an option to select province and territory. For most of you, you're particularly concerned with the laws where you work. So you can hit this button, and then I choose BC here, and it takes me to a page with the law in British Columbia. This beginning here says what the section outlines, but on the left here, there is a table of contents that allows you to jump to the section that's most interesting to you. So if we really want is to see a snapshot that covers the law, this snapshot here gives you some high-level stuff on relevant laws. Then you can go, so for example, it says here, the Adult Guardianship Act creates mechanisms for responding to abuse, neglect, and self-neglect of vulnerable adults. If you want to know more about the Adult Guardianship Act in particular, you can jump ahead to Section 3, which goes into quite a bit of detail about the Adult Guardianship Act. There also is a section on key laws and regulations that provides you with links to all the laws. So if you see here, if I click on Adult Guardianship Act, it takes me outside the web page. It opens up a new window where I can look up the Adult Guardianship Act and review anything I want about it. And then you can go back to that window because it opens up in a separate window, the legislation. If you're reading something and you want to see the endnotes, more information about where the legislation is linking to, there's an endnotes section at the bottom. So you can kind of scroll back and forth between the sections that matter to you, or you can read the whole thing from beginning to end. The key context section at the end also has hyperlinks that take you to the different organizations that can be helpful. Now, if you go back to just click on our logo, it'll always take you back to the landing page of the website, and you can see the other features you can connect to from the landing page. So we have a section on elder abuse and neglect generally. If you click on that, it's the arrow. This covers not the law, but just some basics on what is abuse and neglect. And so that's kind of your introduction to elder abuse and neglect. For many of you, that's something you're very confident in already. We have a set of 12 guiding principles for best practice that we've refined over the years. They're lenses for inclusive practice you can see here. And then if you scroll a little lower, you can see we have some federal laws that we discuss. I'm just going to click on that briefly. You can see under the key laws section that in this section we discuss the Criminal Code, the Immigration and Refugee Protection Act, the Personal Information Protection of Privacy, Protection of Electronic Document Acts, PIPEDA, and then the other privacy legislation. I'm just going to go back to the landing page because I want to also identify that one of the things we've included in this new elder abuse and neglect guide is a section on laws on reserves. So if an older Indigenous person is living on reserve, there may be some different legislation that applies to their experience. So this section talks about family and property rights, and in particular the Family Homes on Reserves and Matrimonial Interests or Rights Act, and links to some other resources that can help you in this situation. And now, I encourage you to look at some of these resources that can provide you with more information if you need more details, and also to email us if you have other ideas about resources that can be helpful in any of these areas. I think of the practical guide as a bit of a living tree, so it's going to grow and expand to suit the needs of people who are using the guide. Now I'm going to switch back to my PowerPoint presentation here. So what I want to do is cover some of the laws that are relevant to abuse and neglect response, because I think that's what some of you are here today to hear about. What do laws actually say? So there are 3 kinds of laws I want to cover today. I want to talk about adult protection legislation, which is available in some but not all jurisdictions in Canada. I want to go through family violence legislation, which is available in every jurisdiction in Canada. Particularly because often I find often legal summaries of abuse and neglect legislation tend to stick to adult protection laws and not cover family violence legislation. But I think it's an important part of our kind of elder abuse legal response toolbox, family violence legislation. As well, I'm going to talk about laws that apply specifically to responding to abuse and neglect that's happening in long-term care. There's some laws that I'm not going to cover today, but that are covered in the practical guide in some of the jurisdictional profiles. For example, in some jurisdictions, the public guardian trustee has jurisdiction to respond. They have unique powers in every province and territory. In Quebec has its own unique legislation that relates to the role of the Human Rights Commission. Oh, I just got a heads up from Benedict that you can't see my slides, so I'm going to try to reshare and see if I can get the right slides. Thanks, Benedict. Is that working now?
Yes, it is.
Okay, perfect. Sorry about that. Thank you for letting me know. So also Quebec has very unique legislation that allows its Human Rights Commission to respond to exploitation of older adults. And Manitoba has very unique legislation dealing with abuse and neglect of adults who have been living with a mental disability since the onset of adulthood. So those are covered in the profiles on the website, but I'm not going to talk about them today because they're quite unique. So the abuse and neglect laws available in each province and territory are just different. Each province and territory has taken a unique approach to developing laws to address abuse of vulnerable adults and creating public agencies to respond to abuse and neglect, and also developing nonprofit agencies and funding them to support seniors. All of this reflects a unique policy choice. I'm not going to express any opinion today about which is the best way to respond. The provinces and territories have unique issues, taken unique policy positions, but what I want to do today is help you to understand the landscape. So let's start by talking about adult protection laws. Adult protection legislation was created to respond to abuse and neglect of vulnerable adults or adults in need of protection. This is not just elder abuse, and it is broader than elder abuse, right? So this kind of legislation could apply to abuse of adults living with a disability who are not older adults, and it's not going to apply to all elder abuse, because if the older person is not a vulnerable adult within the meaning of the legislation, they would not benefit from a response under this legislation. So each of these statutes will create designated agencies and give them a responsibility to respond to abuse, neglect, and self-neglect. Often reporting to these agencies is not mandatory, but these agencies have a mandatory duty to respond. The laws will define key terms like abuse and neglect and vulnerable adult. They will indicate what kinds of abuse are covered. It's not the same everywhere. In particular, sometimes financial abuse is not covered, and they give unique but sometimes quite broad powers to respond. So this slide shows you the provinces and territories in Canada that have adult protection legislation. So Nova Scotia, Prince Edward Island, and Newfoundland have laws called the Adult Protection Act, and they are sort of self-contained adult protection models. Quebec has its own unique newer legislation, the Act to Combat Maltreatment of Seniors and Other Persons of Full Age in Vulnerable Situations. BC has an Adult Guardianship Act, and Part 3 contains a section on abuse and neglect response that's similar to the adult protection legislation you find in Nova Scotia, Prince Edward Island, and Newfoundland. Yukon as well has a much longer statute dealing with decision-making more broadly, and Part 4 deals with adult protection. And then New Brunswick has a law called the Family Services Act, and Section 34 to 42 of that statute deals with responding to abuse and neglect of older people. Most of the statute deals with responding to keeping children safe, but there's a narrow slice focused on abuse and neglect. So these slides where it's highlighted in blue, you can see there's a hyperlink to the legislation, just like there's a hyperlink on our website to CanLII, which is a free place to get information on laws in Canada. Now, these statutes can give very broad powers to response, and so that is one of the reasons why we need to be circumspect and careful about empowering legislation to respond to abuse and neglect. Here's an example of some of the powers you find in BC's adult protection provisions. There is a power to conduct investigation, which is very common, access private information, enter premises and examine the adult with a court order, make a report to police or PGT, and generally adult protection legislation will say that if responders think a crime has occurred, they must report to police. Get a no contact order, so prevent a person from accessing the vulnerable adult. Develop a support and assistance plan, take into consideration the health, safety, and social services needs of the older adult and offer it to them. They can also, in BC, we can impose a support and assistance plan with the court providing an order to do so. And there are some powers in an emergency context where the designated responders think that the adult is at risk to remove the adult and put them in acute care or respond in other ways to provide health care without getting to a court order, getting a court order from a judge first. These are extreme, the final step is an extreme response that would only be used in very limited situations of significant risk and for a temporary period of time to allow a support and assistance plan to be developed and approached. So just comparing these different legal frameworks. So in Nova Scotia and Newfoundland, there is a public duty to report elder abuse and neglect. It's a mandatory reporting regime. In Prince Edward Island and Quebec, it's not general mandatory reporting, but certain individuals do have a requirement to report. For example, in Prince Edward Island, it's people who kind of have a caring relationship with older people in a professional context that are going to have a mandatory duty to report concerns about abuse or neglect. And then in British Columbia, Yukon, New Brunswick, and Prince Edward Island, there's no general duty to report elder abuse and neglect, but as I said, if a report is made, there is a general duty to respond on behalf of the agencies who are the designated under the legislation must respond. So now I want to switch gears and talk briefly about family violence legislation. And one thing that's useful about it is you know that it exists everywhere in Canada. Each province and territory has some kind of law that defines family violence, defines family member, applies to family violence, which is often defined similarly to abuse in an adult protection regime, allows response in the context of risk or if family violence has occurred. These statutes generally allow the courts to intervene by making a court order. In that sense, the response is limited, right? It's one kind of response, although there are generally a few different kinds of court orders that judges can make use of. And the legislation will indicate who can apply for a court order. And I'll cover that on a slide in a moment. So this slide shows you all the jurisdictions in Canada that have a specific family violence statute. You can see the trends in the naming. They generally have the words Family Violence Act, Domestic Violence Act, Violence Intervention Act, and there are hyperlinks on this slide. However, in the other jurisdictions that are not on that slide, BC, Ontario, and Quebec, there are still family violence provisions. They are just found in a bigger statute. So in BC, they're found in the Family Law Act. Same with Ontario. In Quebec, they're found in the Code of Civil Procedure. Now, because Indigenous people living on reserve are generally considered within the federal jurisdiction, we have an additional law called the Family Homes on Reserves and Matrimonial Interests or Rights Act, which allows judges to intervene to address a number of family law situations on reserve. However, if you are an Indigenous person living on reserve, the provincial family law and this federal law actually applies to you. And in addition to that, there might be band council laws or policy that has been developed related to abuse and neglect response. So it's more complex on reserve and you need to look for laws in different places. Multiple laws could apply to family violence. So just to give you an example of the definition of family member, Here's an excerpt from the Northwest Territories. The following people can apply for an order. So you can have lived in an intimate or family relationship. You could have a spouse with the abuser or be the abuser's spouse or former spouse. Or here it says you could be the parent or the grandparent of someone experiencing abuse. And this is an increasing trend in amendments to family violence legislation, is to specifically include grandparents in the legislation. Some of family violence legislation requires that folks actually live together for it to be possible to get a family violence order, so it's not always going to be available in situations of abuse and neglect. This slide is just quickly to show you that family violence definitions are very similar to abuse and neglect definitions you find under adult protection legislation. They include sexual abuse, forcible confinement, psychological abuse, emotional abuse, various kinds of financial abuse. In some ways, family violence legislation can be a little broader because it sometimes allows for a response when there is a risk of family violence and the abuse and neglect has not already occurred. That can be a distinction to be aware of, but you always want to look at the specific wording of the law that applies in your province and territory, and that is why we developed the Practical Guide to Elder Abuse and Neglect Law in Canada. So to give you a sense of the kind of terms that you can get with a protection order, no contact provisions are common. In order to keep the abuser away from the family home, or to give exclusive occupation to the person being abused, an order regarding possession of firearms. The order can direct police to help a person remove their belongings or remove themselves to get to a safe place, such as a transition house or another kind of housing. It can order an abuser to get counseling, but really the judges will have discretion to consider whatever is necessary to protect a person who is at risk of family violence. How do you get an order? Somebody must apply to court, or there must be a family law case ongoing that would allow a judge to kind of realize there's some risk. Generally what happens is someone applies to court to get an order, which raises the question of how do you pay for help. Most jurisdictions, legal aid will help someone if they are experiencing violence, and so they will provide a lawyer or pay for the lawyer to help you get that court order. And criminal charges are not necessary generally to get a family violence order. It's a civil remedy. But it is possible also to get family violence type orders through the criminal system. So I developed this slide at a glance just to show you that there are different kinds of protection orders you can get in Canada. If there are criminal protection orders and civil protection orders. The criminal orders are called either a peace bond or a Section 810 recognizance. They're called a Section 810 because it's found in Section 810 of the Criminal Code. And we generally call them peace bonds. It's common that someone who's released after being detained by the police there'd be some kind of peace bond saying they must keep the police and stay away from the person it's alleged that they're harming. So it's a different process to get a peace bond compared to a civil protection order. If you call the police because a criminal act has occurred and they're releasing the abuser with a peace bond, the police and the lawyers who represent the state are doing all the work. Nobody has to go to court to get a peace bond. The police would sort of set that chain in motion if they see a safety concerns. There are no fees because you don't have to apply a lawyer, and it can protect you from anyone. Peace bonds are valid throughout Canada. Civil protection order, as you see in the second column, it's a little different. Someone has to apply to a judge. The criteria is going to vary depending on the legislation. There are court fees involved, but if a low-income person can generally get those court fees waived. The limits in terms of who it can protect you from is it can only protect you from a family member. So family violence civil protection orders are a creature of family violence legislation. So they deal with family violence and relationships, interpersonal violence in family contexts. So more limited in terms of who it can cover. Family violence, civil protection orders, some of them need registration outside of your province. If, for example, you move provinces, it's different in each province and territory. Some jurisdictions have legislation that says they recognize all protection orders without registration. In other jurisdictions, you would need to register your order or the older person's order if they move. So now just briefly to cover abuse and long-term care. I know that's a great concern to everyone. This is an area where there is not legislation everywhere in Canada, but you will find two different kinds of legislation. One is, and I'll go to that slide, there are 4 jurisdictions in Canada that have laws called the Protection Persons in Care Act. And these statutes are short statutes, similarly named, and they generally require everyone to report abuse or neglect of a resident, and they require the people running those homes to respond and notify certain individuals in the case of abuse. In some other jurisdictions, a requirement to respond to abuse and neglect is found in legislation that applies to long-term care. So this slide gives you some links to legislation in BC and Ontario that governs long-term care and retirement homes and requires a response to abuse and neglect. Be aware that the Ontario slides links will become inaccurate soon because Ontario is in the process of bringing into force new legislation. It doesn't significantly change a civilian's duty to respond, but it slightly alters the response requirements of the operators. Really, we have legislation that applies specifically to abuse and neglect of older adults and other people living in long-term care settings because we recognize that they are all vulnerable adults. And that in providing congregate safe housing, we have committed to keeping them safe in those housing situations. So now, before I wrap up, I wanted to say something briefly about best practices in response because the law doesn't always tell us everything about abuse and neglect response, and abuse and neglect can put us in some really challenging situations where we're just kind of not sure what to do. The Practical Guide to Elder Abuse and Neglect Law in Canada has 12 guiding principles that we developed over the years, and I've just kind of starred the ones on this slide that I want to say something about briefly today. But I encourage you to take a look at all of them in your own work. So first of all, and this is the first one for a reason, it's foundational, we need to listen to the older person who seems to be at harm or is being harmed. Always our responses should be grounded in what they want as long as they understand their situation. Other people shouldn't be controlling the lives of older adults who have capacity to understand their situation. We want to focus on actions and services that the older person identifies as helpful and not invasive. And supporting that older person is going to be a journey over time of building trust and rapport. One of the challenges is that if we go behind people's back and do things with the well-meaning intention to improve their lives without consulting them, is we tend to break trust, and breaking trust will undermine our ability to help that person over time to be safe. It's really important to respect and support decision-making autonomy. Most people who have experienced abuse and neglect, they may be overwhelmed and afraid and unsafe, but they have enough capacity to understand their situation and make decisions for themselves regardless of their age or disability. And they have a right to make choices that we might think put them at risk. Some people do not have capacity to understand their situation, and those adults may require a different kind of intervention, and that is why adult guardianship laws, adult protection laws exist. But most adults understand their situation. They may require support and assistance, but they don't require a kind of coercive intervention that goes over their decision making. As a result of this, it's really important to seek consent or permission as much as possible, even to make a phone call. You know, if there's an urgent situation and somebody's in the moment of being assaulted, you may make the decision to call the police without consulting them because they are in danger and they're protecting themselves. Most situations, you want to get permission to have even a phone call with a third party, because that can be considered an invasion of privacy, and we need to respect people's decision-making autonomy. As part of that, you want to be checking regularly to make sure the older person is still comfortable with how events are unfolding. People are entitled to change their mind about how they want to proceed with elder abuse and neglect and whether they kind of want to do anything. I encourage you to respect relationships that matter, and often older people will want to keep other people they care about safe as much as they want to keep themselves safe. And unfortunately, sometimes the person who is harming them is someone they care about a lot, and that may mean that in supporting the older person, you need to help them get services to the person they care about, even if they're abuser. So learn about the relationships that matter to that older person, and please respect those relationships. So just by way of some final concluding thoughts, there is no single law that applies to elder abuse and neglect law, and that's why we developed the practical guide to help you navigate this situation. There are lots of different laws that could apply. Provincial and territorial laws dominate, but the criminal law can apply in some situations. Is elder abuse a crime? The answer is generally maybe. Sometimes it's a crime and sometimes it's not. The Advocacy Center for the Elderly in Toronto developed this fabulous criminal and non-criminal abuse and neglect wheel that shows you how criminal code provisions can align and not align with the experience of abuse and neglect. You know, so an assault, a physical assault, is easier to prosecute as a criminal offense. When someone is physically harmed, it's more clearly an assault. Emotional abuse can be more challenging to prosecute, but it could amount to a threat. It could amount to some kind of extortion. But not every kind of abuse and neglect is going to be a criminal act. I'm going to flip ahead to my notes here. Is it civil or criminal? You know, sometimes I have heard folks say that a matter is not criminal because there is a civil remedy, meaning either there is a response available under one of the laws that I have mentioned earlier in these slides, like the adult protection legislation, or that there is a way to get compensation by suing a person in court. Say they've misused their authority under a power of attorney and stolen money. Now, my response to this statement is this is the wrong question to ask. And I encourage you to ask instead, how can we respond to this unique situation of abuse? And here are some examples on this slide of questions you can ask. Has a crime occurred? What does the older person want or need? Could a criminal justice system response be helpful? Is there an urgent safety issue? How can we enhance the person's safety? Where is the abuse occurring, right? If it's in long-term care versus in the person's home, that's going to indicate different kinds of response options. Is it a family relationship? Is it not? Again, family violence legislation only applies if there is a family relationship. Does this older person understand what is happening? We call that having capacity. So can they understand relevant information and make an informed decision about their safety? Not the decision you would make, but the decision they could make because they understand enough relevant information. If they don't have capacity, then you might want to consider responding under adult protection legislation because they would be a vulnerable adult. How can you support capacity? Some people don't have capacity when you first meet them because they are terrified, they're experiencing trauma, maybe they have untreated medical issues. But if we support them to get the right care, they might have enough capacity to make their own choices with support. So think about how you can help them to get into a better place and how you can support them to make their own decisions instead of making decisions for them as much as possible. And consider, is there an urgent need for medical attention? But again, we don't tend to force people to get medical care if they have a mental capacity. You know, you hear the expression, it takes a village, and it applies to elder abuse and neglect response as well. The law is just part of the picture, and there are lots of different ways that we can support a person who is experiencing abuse and neglect. And I encourage you to think about all these different facets when you're exploring how to respond to abuse and neglect. You know, a transition house could be helpful to some older people, some not. Some people might welcome police intervention. In most cases, an Indigenous person is not going to welcome intervention because they know that their communities have experienced racialized and unfair responses by policing. We need to be, you know, immigrants, refugees may have a different relationship to police response. So always think about that unique older person when you're considering what is the right response. A common term you may hear when thinking about abuse and neglect response is the idea of complex needs. And I borrow this slide from my friend Marta Rojic, who is a social worker. And I think it's a really important point. Like, it is complicated. But let's not use that as a way of kind of shutting the door, but as an invitation for creativity and holism and thinking about how to respond to a unique older person's situation. We may not be able to kind of fix everything for them, but maybe we can kind of do triage and help in one small way kind of to make things a little bit better. But as we've learned in feminist communities in working with response against violence against women is that responding to abuse and neglect usually takes time. It's a relationship building process. It's a learning process for all of us, working with a unique person. And we can't fix problems overnight as much as we want to. It's rarely ethical to fix overnight, and it really just takes time. You often will hear calls for mandatory reporting, and I encourage you to be thoughtful about that and recognize that people living with violence have had all their power taken away. And what we want to do in responding to abuse as much as possible is support them to have some sense of control of their lives. And so responding without talking to them is not always going to be in alignment with an empowering way of responding to abuse and neglect. So, you know, please be mindful of that when you're thinking about, is reporting the right way to respond? It's just one of many ways we can respond. Sometimes it's the right response, and sometimes it's not. So thank you for joining us today. And here's how you can help us. We want to keep the practical guide alive and accurate for everyone. And we want it to grow and become a useful resource for everyone. So please, as you're playing with the guide and using it in your own work, send us an email if you see something critical that's missing. If something changes in your community and a phone number changes, please let us know. We will endeavor to update the guide as soon as possible, bearing in mind that we're trying to keep it bilingual, so we need to translate everything. And it costs money to keep the guide up to date, and you would not believe how much language translation costs. So please consider volunteering with us if your organization wants to use the guide in your work. Partner with us, like we have partnerships with other organizations, and help us to keep the guide accurate and available in both languages. I'm always reachable by email. You can find on this final slide our Twitter handle if you want to reach out to us. And as I told Benedict, I'm happy to stay here for questions. I know that Sarah's been answering some questions in the chat box, and I know the webinar is booked till 11. As I said to Benedict, if we need it, I'm fine to stay a little bit longer to try and answer as many questions as possible today. But if you don't get your question, please send me an email.
Krista, we had a couple that came up in the chat box that I'll just flag first. The first, Miriam had asked if there was going to be a PDF version. I don't believe so, but I said I'd confirm with you.
Okay, that's a good question. So there is a PDF version for sure of my slides that I'm sending to Benedict with hyperlinks. On each page of the Practical Guide website, there's an option in the upper right-hand corner that says print, and that will formulate a PDF of all the material, and you can print those PDFs whatever you want.
Awesome. Bernice had noticed that Alberta doesn't have an Adult Protection Act, and I had referred Bernice to the Protection for Persons in Care Act, and someone else, Tabitha, had also commented that not all provinces have a public duty to report, and she was surprised. So I'm not sure if you want to talk at all to the differences as to why some provinces have a mandatory response or legislation directly on adult protection and some do not.
You know, I think, as I said, I think each jurisdiction has taken a unique response, and it depends on the resources available in that province and territory. You know, even if there isn't legislation, there are often ways that you can respond in supporting an older person. So even in the absence of adult guardianship or adult protection legislation, there are lots of things that we can do. So I'm happy to be a resource for jurisdictions that are considering law reform, but there are lots of different ways to do this. And in a way, the best way we can help older adults is by looking out for, you know, people in our communities.
Okay, so I think the rest of the questions are in the Q&A. Krista, do you want to just read those or do you want me to read them to you?
I can read them if you want. I had a couple of ones that stuck. Well, one of them being actually wanting to know if there was a way to have further presentations hosted about this guide throughout. So I think Jennifer in Ontario is involved with a local elder abuse prevention network and wanted to know if it is possible for you to consider maybe doing more presentations about this.
Yeah, absolutely. And, you know, Elder Abuse Prevention Ontario has just come on board as a partner. So we're planning to work with them to put on an Ontario specific webinar that will be a bit of a deeper dive into Ontario laws. So maybe sit tight and see if that webinar addresses your needs. And if not, feel free to reach out to us. I've also, you know, the BC Association of Community Response Networks is planning a webinar in October. I'm doing a webinar with the United Way they're now United Way British Columbia on May 9th. You can find information about that on our social media page. And I am in discussions with the RCMP about organizing a webinar. But yes, happy to do more sessions.
Wonderful. So your contact information was shared in the chat box and it will be available in your slides as well. So people can get in touch with Krista to explore this further. So we have a few more questions that have come trickling in while we were speaking. So one that came in early was regarding how the law defines the age of the people we call older adults, or, you know, when we talk about elder abuse, what exactly is the age definition there?
That's a good question. And in generally, it doesn't matter because because adult protection legislation generally applies to vulnerable adults. So really it's an adult. So although we think of adult protection legislation as a critical part of our abuse and neglect response framework in jurisdictions that have that kind of law, they are all age neutral, except that they only apply to adults. So if you're thinking about abuse and neglect of children, you're looking at child welfare legislation. But other than that, adult protection legislation is age neutral.
Great. We have a few more coming in. Kirsten is asking, what are repercussions for not reporting when there is a mandatory reporting in place? That's first part of the question.
That's a good question. So I can't give you a general response because it kind of varies from province and territory, but the laws will tell you, and we cover that in our practical guide summaries, but in some jurisdictions, technically, if you don't report, you could be subject to a fine, and the legislation sets out the mandatory amount of that fine. But to be honest, I've never heard of anybody being fined. But yeah, technically, there can be a fine attached to failure to report in some jurisdictions. But there's no response there's no answer for that's accurate for every province and territory in Canada. If that makes sense. Each statute that applies and imposes a mandatory response has its own language about what could happen if you do not report.
Okay, thank you. And I see actually Sarah is might be responding to the next question in writing, but I'll read it out for everyone. Yvonne is asking, is there a synopsis anywhere that identifies various criminal codes provisions that can be applied to elder abuse situations?
Yes, actually, the practical guide does have in the federal laws section, there is a section on the criminal code that lists quite a few criminal code provisions that could be used to charge someone if they have abused or neglected an older adult. And I did a presentation for the RCMP specifically on that topic, and so I think that that is available. I'll see if I can get the link to Benedict. I also wrote an article for Bartok on specifically that point, so maybe Sarah can put a link to the Bartok article in the chat box for you. But it's quite a range, you know. We have specific provision for that could apply to neglect, such as Section 215 of the Criminal Code, failure to provide the necessaries of life to a dependent adult. I think that's an important provision to be aware of. We have at least 20 different provisions that could apply to financial abuse of an older adult. And in particular, Section 331 deals with abuse of a person who has responsibilities under a power of attorney. I know sometimes police will not be aware of that provision and they'll say, oh, that's a civil matter, but absolutely there is a specific criminal code provision dealing with abuse by someone holding a power of attorney for an older adult. And criminal code provisions are generally age neutral unless they apply to children. So, you know, assault, sexual assault, manslaughter, murder, all these provisions apply to someone regardless of age. Extortion, fraud, they all could apply in different situations of elder abuse, but there's a table in the practical guide that lists the number of the code and the particular offense. So you can look at that in your own time. If you see something key that you think is missing, feel free to email me.
That's great. Thank you. We have a question now regarding long-term care from Trish. She's asking, how is it that long-term care facilities can refuse leave from the facility with family if, one, the resident is able to decide for themselves, and two, the power of attorney or legal representative and the resident want to leave for an outing?
Okay, now that question I think relates more to COVID policy.
And actually, she was asking, now that the mandates have been loosened, I skipped that part. My bad.
Okay, so that's a great question. So long-term care is not jail. So some people who are living in long-term care, a lot of people living in long-term care will still have capacity to make their own decision about whether they want to come and go. And then it's not appropriate to prevent them from going on an outing. Now, facilities may have policy about the rules of the facility, and it may be that you don't want to live in don't want to live, or you don't want your family member to live in a facility that has policies that you don't jive with. You have to choose a facility, recognizing I know that it's the long wait list, but they can impose rules that are not illegal, and when you agree to move in there, it's a contract, right? They're saying here's the living environment we provide, and you're agreeing to live there. So they can impose some rules, but they can't physically restrain people with mental capacity and refuse to allow them to leave. If you're wanting to make a decision for an older person about whether or not they can leave because they cannot make that decision for themselves anymore, you need to have authority to make decisions for them. And often what happens is that different family members have different views, and that will put facilities in a difficult situation. But if somebody has appointed someone under provincial law to be their substitute decision maker for health or personal care, that person can make a decision about day trips to leave the facility. Some long-term care facilities actually have rules about physical restraint, and you will need, in some cases, agreement of the substitute decision maker to prevent them from leaving the home. So in some cases, preventing a person from leaving long-term care actually violates their own rules about long-term care. So I guess the answer really is it depends on the situation, it depends on the jurisdiction, but long-term care legislation should not violate human rights law and other constitutional legislation. So you can't say, we can't create laws that say people with disabilities don't have the mobility that people who do not have disabilities have. So I think there are some challenges in applying long-term care policy. There's a lot of concerns about disease management, right, and contagion control. And facilities need to develop policy that does not violate other kinds of laws. If you think you're running into a facility in that kind of situation, I'd encourage you to try and get some legal help. We do have legal organizations listed in all the provincial and territorial snapshots.
Thank you. Well, are you okay to continue? I think we have quite a few more questions. Sure. So we have George, who is in Ontario, and he's asking, what do you do when you are in court and all agencies, PGT, police, say to you, because your dispute is before the court, we cannot investigate or do anything?
It's very general. So can you repeat that question? So you're in court.
Absolutely. So you are in court in Ontario, and all the agencies such as PGT, police say, because your dispute is before the court, we cannot investigate or do anything. And if you need a clarification.
Very general. Yeah, that's very general. I'm not sure that I can answer that question. I think that one of the things you will deal with is that courts are not going to want multiple courts dealing with the same problem at the same time. So if one court is dealing with a matter, a judge is going to want to let that legal process run its course before getting involved in a situation. And specific legislation may clarify how to deal with a situation where multiple laws could apply. But I don't know if that person's on the line and you want to clarify your question, or if you want to email me after. I'm not sure I have enough information to answer that question in a helpful enough way.
Okay, so George, if you are still on the line, I'm trying to see if I can find your name in the list. If you are still around, please add a few more details or contact Krista at her email address directly. Okay, in the meantime, let's ask the next question, David, and I think this might require a bit of clarification in terms of what CCEL does. David is asking, when should a seniors advocate or a person who might intervene call your office before calling the police?
Oh, yeah. Okay, so I can answer that question. So my office sort of looks more at system change at the macro level. So we do research and we create educational tools to help people understand the law. We don't provide people with legal advice. If you are not sure what agency to call, you can email our office and I can try to direct you to the right agency. Please don't feel like you need to contact me before you call the police. If there's an urgent situation and somebody is at risk, it's your discretion whether you think it's appropriate to call the police or not, unless you have a job where policy requires you to call the police. If it's not an urgent situation and you're not sure what to do, but you think you might want to call the police, and you're looking for some help in figuring out what to do, we do have in the practical guide links to organizations that can help you problem solve. For example, in British Columbia, you maybe reach out to Seniors First BC. They might be able to help you figure out if you could contact the police. But unless you work in a job where you're required to call the police, it's always up to individual discretion whether it's the right thing to do. But I encourage you, if it's not urgent, to be talking to the older person and figuring out what they want to happen, because the unwelcome interventions by police can be not a good thing for older adults in many situations.
Thank you. Michelle is asking, could the laws applying to long-term care facilities not be extended to the entire community in some way?
They could, but I'm not sure that's a great idea. We be so the reason why we have mandatory, and if you're the reason why we have mandatory reporting in long-term care is because we recognize that older people living in long-term care are vulnerable, and that we've created this communal housing, and that people who move in there, if we're running those facilities, we have a duty to keep folks safe because they can't get help on their own. Often they can't walk, or they don't understand what's happening, or they have significant disability or frailty. And if they get hurt, the consequences of it's hard to get better when you're that frail. People living in community, like young people, have a right to make choices about what to do when they're living in situations where there's some safety problems. And just the fact that you are getting older doesn't mean you lose your decision-making autonomy. So I think there are ethical reasons why extending the rules we have in long-term care to the broader community would be problematic. On the flip side, I will say that as we've noticed throughout the pandemic, although we have these stronger rules about abuse and neglect response in long-term care, that hasn't necessarily resulted in long-term care being a place where people feel safe. So long-term care legislation hasn't necessarily done the job we've wanted it to do, possibly because there's lack of resources put at enforcement and regulation and inspections. But ultimately, I think long-term care is a bit of a broken system, and it doesn't really provide a model that we want to replicate around in our communities broadly. So,
thank you. And we kind of have a good follow-up question from Claire regarding, long-term care, COVID things. Do laws flex in times of crisis? Like how? So let me break it down. There are several questions in the same paragraph. So the first one is, do laws flex in times of crisis? And the second one is, how do laws justify things like triage protocol or the prioritization of healthcare for younger or able people versus older disabled people or people living with dementia? And then the third part of that question is there a place for an investigation into some of what happened during COVID in long-term care?
whew, okay. That's
I
a
know,
big question.
it's a big one.
Okay, so I'm going to try and answer some pieces of it. Do laws flex? Well, laws provide a legal framework. And if by flex you mean do they change, I would say law reform is slow. So if we see that our laws are not working and governments want to change them, they have to go through a process involving Parliament. So law reform is not a quick process. Now you will see for Ontario next week, the new legislation applying to long-term care will be coming into force, and that would be an exceptional example to me of law reform applying to elder abuse change happening quickly. Usually it's a slow process, but not everything is laid out in the law. Often things are laid out in policy, and I think the things that you're referring to around prioritizing care for younger people or more able-bodied people is not something found in law. It's found in policy, or it maybe is just a practice. And those policies and practices need to be developed in a way that respects human rights. And prioritizing people who do not have disabilities over people with disabilities in terms of choices about triage and care, I would say arguably violates the human rights, which protect the rights of people living with disabilities to be free from discrimination. So as policy gets developed, I think it's important to be constantly checking to make sure it's in alignment with human rights values as well. That said, in a given moment, in a healthcare setting, in a context of limited resources, I think particularly during the pandemic, we've probably seen healthcare providers often doing the best they can to figure out who to provide care to first. And I don't want to place judgment on any of those decisions. I think people are often doing the best they can in really challenging situations. So I encourage people to check with policies and make sure that they are in alignment with human rights laws. And if you see a policy that troubles you, certainly I have talked to people living with disabilities and their caregivers, and they found that, situations like, for example, a person with significant physical impairment is offered end-of-life treatment, whereas this person's had physical impairment their whole lives. It makes absolutely no sense why they'd be considering medically assisted death or withdrawal of care when they've always had disabilities and lived a very meaningful life. So sometimes policy choices or practice choices about how to implement policy and care can be ableist. And so if you see those kind of situations, I encourage you to challenge those situations, ask to speak to a supervisor. It's hard in healthcare settings. We feel like we have no power in the face of fast-moving, physician care settings, but everyone has a right to care, and discrimination in healthcare is not acceptable.
Thank you very much. Let's see, one more. Can we do one more?
Yeah.
Crystal is asking or is saying some provinces stopped civil suits at the beginning of the pandemic. Is anyone being successful with criminal charges for death?
It's a very interesting question. So I think that we have plenty of stuff in the criminal code, but I think often the lawyers who prosecute criminal elder abuse and police lack guidance on how to approach charging and prosecution. And I do think we need more robust policy and practice guidance for these sectors. So I think we don't see a lot of prosecution. Hopefully COVID has shined a spotlight and we'll start to see more prosecution when the older adult or their family welcome prosecution as a step. There are a number of civil litigators who are exploring class actions and mass torts as a way to hold facilities accountable for abuse and neglect occurring in settings. And there is a presentation on that topic at the Elder Law Update being held in a couple weeks. It's a program of the Continuing Legal Education Society of BC. I helped them develop the program. They have some great presenters. Maybe Sarah could put in the chat box a link to register for that webinar. It's not free. But they think they do have a nonprofit rate. So that might be an option for learning a bit more about that question. I know that the House of Commons Justice and Human Rights Committee was accepting submissions last spring of last year on law reform and prosecution in elder abuse and neglect response. And there were great submissions from experts from across the country thinking about this issue. So you may want to take a look at some of the briefs. They're all available on the House of Commons website. It's the Justice and Human Rights Committee is JUST, J-U-S-T. We have a blog post on that process quite recently published, I think. So you can also look there for more information on that.
Great. Let me see. I think I had seen one more question from Michelle, but it already got pushed by more comments and questions. Oh, here we are. Many injustices to older people in the community are in violation of human rights. How would a senior be able to even begin to make a case for themselves?
It's a huge question. To get a remedy in human rights context often requires filing a complaint with the Human Rights Tribunal, whether it's usually that would be the province or territorial human rights tribunal, filling out paperwork, making a case, maybe there's a mediation, maybe there's a hearing, and then you might get a remedy that makes change, but you're probably looking at a couple years to get a remedy under human rights tribunal system. It's just the nature of legal systems are quite slow, and a lot of human rights systems are quite bogged down with COVID policy complaints, so they are increasingly behind schedule. Um, Many jurisdictions in Canada have a human rights commission, and they can be a good resource if you're dealing with a situation where you think there's been a violation of human rights and you're not sure what to do. They may be able to identify some different kinds of steps you could take. I think often when you are in a situation where you feel like an older person's human rights are being violated, it can be helpful to open up a context, a conversation to talk about human rights violations. Litigation can be a useful way to get a remedy required, but sometimes people are just not aware of human rights law. And if you can find a gentle, creative, collaborative way to help these institutions see where their practices are ableist or ageist, you might find you get a little bit of traction. But system change, policy change, like elder abuse response, doesn't happen overnight. And often we need to be willing to collaborate with challenging institutions to help them see how they need to change their practices. But that kind of positional loggerheads approach doesn't always work. And we have to try to make friends with challenging allies in order to affect system change, I think.
Thanks. And talking about policy change, another participant is asking you to talk a little bit of the law versus policy question. Like what's the difference and how do they interact with each other?
That's a really good question. So the law is the law, and we've all got to follow it. And then there are some laws that are even more fundamental, like constitutional law and human rights laws. So discrimination laws are constitutional or quasi-constitutional, and so all of our laws need to jive, be in alignment. They can't counter human rights law. So you have these, like at the top of the pyramid, you have constitutional and human rights law. Then you have other general laws. Policy needs to be in alignment with those laws. Policies tend to be created at an institutional or organizational level, and they provide more detailed guidance on what to do when you're following those laws. I would encourage you to think of laws are sort of the skeletal structure, and the policies more like the muscles and the veins that helps give life to that law in a way that's meaningful. So the laws are, hopefully that's not a terrible metaphor, but the laws provide the structure and the policies provide more details. If you work for an organization, you have to follow their policies, but you and the organization also have to follow the law. Policies, like a law may be the same everywhere in your province, but each organization is going to develop its own policies, and they may vary slightly, but they all have to follow the laws. Policies are easier to change because you don't have to go through Parliament, although some organizations are so bureaucratic that it might seem like policy change is harder than law reform. But law reform is slow, you got to go through Parliament, so policy change can be kind of faster. In between policy and laws, we have these things called regulations, which are they are a kind of law that can be changed more easily by Parliament. And those regulations or regs tend to provide a little bit more detail. So when you're looking at what your responsibilities are, you're looking at human rights law, you're looking at the statute, the act. It's called an act or a code. And then the regulation, and then you're looking at your policies that are organizational. You might also, if you are a regulated professional, you might even have practice requirements or practice guidelines or code of ethics that apply to code of professional conduct that applies to your work. You know, I'm a lawyer, and so I have a code of professional conduct. We have law society rules, and those apply to my work. If you are a physician, they also have a code of ethics. Nurses have lots of practice guidelines. So you may find that in addition to sort of policy, you have these practice guidelines or code of ethics or other rules that apply to your profession. It's really, there are so many things that govern our work, but in some ways, law is the foundation that everything else needs to kind of jive with.
Okay, thank you for that. And I think that's the end of our list of questions for now. Hopefully I haven't missed any. Sarah, I know did a fantastic job also kind of dealing with them as they came in. So for the still 28 people who are here, thank you so much for staying. You will be able to connect with Krista at her email address, kjames@bcli.org, or you can go through CNPA if you want. We'll forward the information and your email to Krista. And for all of you who were present today, you're going to be receiving a follow-up email in the next couple of days that will contain a link to the slides and the recording. So you'll be able to revisit this and digest it and take the time you need. Sarah and Krista especially, thank you very much for doing this today. I think people who participated really got a lot out of it. We covered a lot of ground. It's a
very interesting questions.
Fantastic resource and fantastic questions. I think that really people came prepared for this one.
And Benedict, before,
yes.
as everybody signs off, let's leave the line open for a few minutes so I can just kind of scroll up through the chat. I'm
absolutely
curious to see how people framed their questions, because it kind of helps me in thinking about communicating about the law and what I missed. I see George is going to email, so that's great.
That's great.
No, I said I can't provide legal advice to people, but my role is really to help you understand the law and connect you with organizations that can help you. As with Benedict, we also work at you know, a national level, thinking about system change. And you know, I worked with Benedict and the CNPA's fabulous project on Future Us. And so there's some problems that can't be addressed in the law, but looking at your questions also sometimes helps us think about other ways to think about system change and policy reform. So thank you for all these questions. They're enormously helpful to people, to me in my work. And if you see any issues with the guide, things that are missing, feel free to send me that email. As I said, it's a growing project, and some things are hard to add, but adding links to important organizations in the provincial, territorial snapshots, that's not so tricky for me to do. So I can make that change fairly quickly.
And before we close off, and while you're reviewing the chat one last time, is there anything else that people can do to support the work of the CCEL, to support the guide in any way? I know that you already made a bit of a pitch earlier, but now that you've kind of thought it through some more.
Absolutely. You know, as I said, we're a nonprofit like a lot of you, and we need funding for every single project that I work on. And so in order to keep the guide accurate and up to date, I do need funding for staff time and for translation to make sure it remains a bilingual resource. I know Ontario is changing its laws next week. Newfoundland has some amendments to its adult protection legislation that I know will be coming into force in the next year or so. Prince Edward Island has developed supported decision-making legislation. It's just gone through first reading. I'm super excited about that, but it means we have to update the practical guide to reflect these changes that are happening. So usually law reform is slow. I always say law reform moves at the pace of a turtle, but when you've published a website that summarizes the law reform somehow speeds up. So if your organization, if you can't hear from a government, a provincial or territorial or government, I encourage you to think about, if you want our website to be accurate for your jurisdiction, we're going to need your support to make that happen. So please reach out and explore how you can partner with us.
May they hear you. Thank you so much, Krista. And also just to let you know, the chat box comments and questions are being saved automatically, so I can always forward that to you later if you need it. On this note, I think it's time to let people go because it is 11:24 here in rainy, haily, almost snowy Vancouver. Stay safe, everyone. It was lovely seeing all of you today, and we'll be connecting again shortly, hopefully in June for WeAdd, if not before. Thank you, Krista.
I just saw a question from someone
Oh,
who
no.
said, is the law the same in Nova Scotia and BC when it comes to adult protection?
I saw that one earlier. I
So
think
all
Sarah
I'm
had
going to
addressed it.
say right now, because I don't want to do a detailed compare and contrast, is they are definitely different. One of the key differences is Nova Scotia has mandatory reporting. But I encourage you to look at the law in Nova Scotia if that's where you work. If people are really interested in this comparative stuff, I'm happy to develop a comparative table. My sense has been that people really care mostly about where they work, and very few people need to think comparatively. But if you're interested in a comparative table, email me, people, and that's a feature I'm happy to develop as an adjunct to the guide.
That's wonderful. Okay, I think we're really done this time. Or do you see one more that you want to answer, Krista?
No,
All
no,
good?
we'll do more webinars, and
okay.
We'll do this in French.
Yeah, we'll do this in French in the near future, and we can always bring you back for a follow-up if necessary. So thank you so much for being here today, and have a great day, everyone.
Okay.
Bye.
Bye-bye.